I'm criminal defense attorney Neil Shouse. You may have heard that California has a new felony murder rule. Under the old rule, if a person participated in a felony and somebody was killed, he could be charged with murder even if he never intended to kill anyone, and even if he played only a minor role in the crime. But this law resulted in some very unfair murder convictions. I'll give you an example. Suppose you and a buddy go into a liquor store to steal some beer. As you're running out with it, the clerk starts to chase you. The clerk pulls out a .45 and shoots at you to stop you, but he misses and hits a bystander in the parking lot, killing the person. Now, in this situation, you never intended for someone to get killed. You did not even have a weapon. You were just snatching some beer. But under the old felony murder rule, you could be charged with murder because you committed a felony and somebody got killed in the process. Well, the law changed on September 30th, 2018, when Senate Bill 1437 passed. Now, you are only liable under the felony murder rule if you directly killed the person or you play a major role in the killing. The effect of this law has been to shrink down the definition of felony murder. A lot of things that used to count as murder in California no longer do. And this new law applies retroactively. That means that if you had a loved one who was convicted under the old felony murder rule, it may be possible to get him or her resentenced and released from prison immediately. If your loved one is charged with murder or is in prison for a murder conviction here in California, we invite you to call us for help here at the Shouse Law Group.